There we go. Welcome back. It's time for us to proceed. I think by now you all know the standard announcements. Please do try to complete your questionnaires sometime during the course of the day. You'll find that in the links at the bottom of the page. It's the last one on there, participant feedback, and you can even open it up and start it and flip back and forth between things and finish it after when you get another break later on, whatever works for you. But please do help us out by giving us your feedback. One more reminder about the raffle going on. The raffle will be, the drawing will be conducted this afternoon, and you have until about 1 o'clock to purchase tickets for that. So please jump on that link if you want an additional raffle ticket or two. And one more reminder, especially if anybody's new here, to the right of the screen, if your web page is, if you haven't gone full screen with the video, your web page will have Q&A and tech support areas just to the right of the video panel. So if you want to ask questions during the presentation, you can type them in that Q&A area. We'll be fielding those questions at the end of the session. So without further ado, let me introduce our next speaker. Kimberly Buddin is a civil rights attorney currently serving as policy counsel for the American Civil Liberties Union of Michigan. In this capacity, she works with legislators and various coalition partners to advance policies that promote and protect individual civil rights and civil liberties. She provides legal analysis on proposed legislation and testifies before the Michigan House of Representatives and Senate committees. Her focus areas include immigration, racial justice, privacy rights, criminal justice reform, and First Amendment issues, just to name a few. Kimberly also serves as a member of the State Bar of Michigan's Access to Justice Policy Committee and is the inaugural corresponding secretary for the Immigration Law Section. She's a former legal aid staff attorney and a municipal law clerk. The activities in Michigan have drawn the attention of a lot of us over the last couple of years, so I'm sure that many are anxious to hear Kimberly's presentation, Registry Overload, Overview of Michigan's Registry Reform. She will be speaking on the progression and timeline of Michigan's registry, current registration requirements and difficulties, impracticability and general problems of the registry. Boy, impracticability, there's a $10 word for you. It basically means the impossibility of doing what the law requires you to do. She'll break down the ongoing legal and legislative advocacy that's been taking place in Michigan during the Doe's 1 and Doe's 2 lawsuits, legislative responses, our recommendations for reform, areas where stakeholders agree and disagree, and next steps. Kimberly, you are an angel. We are in awe of the Michigan ACLU. Welcome.
I know I'm going to be covering quite a bit, so I want to make sure that we have enough time for questions at the end. So there may be a couple of slides that I go through a little bit more quickly, but happy to provide these slides to any participants that are interested. So I just wanted to also note that I have my colleague, Tim Poxon, here with me today. Tim is our volunteer SOAR specialist, and he works with registrants on a variety of things, including helping them get more involved with the ACLU's registry work, working on helping them learn how to testify, keeping them updated about everything that's going on. And Tim will also be available after this quick presentation to answer questions, as I think his perspective is really, really valuable. So I just want, again, go through, these are the things I'm going to be covering today, the history and evolution of Michigan Sex Offender Registry, the difficulties and practicability and the problems with the registry, the legal challenges that the ACLU and a few others have brought forth, the recent legislation and our recommendations, and then what's really up next for the state of Michigan. Covering history and evolution. So Michigan's registry, like many other states' registries, was established as a response to federal legislation. And you can see here what some of those federal laws are. The first being in 1994, Jacob Wetterling Law, and in 1996, Megan's Law, which was the law that required law enforcement agencies to make information publicly available. in 96, there was also the Pan-Lyncher Act, which required lifetime registration requirements for certain serious offenders and recidivists, quote unquote recidivists. And then the 2006 law, which was the Adam Walsh Act, many people are familiar with. This is the one that really created the registry as it looks now, establishing our tiers and lifetime registration. And legislators really called this a public safety measure. And you can see here, I pulled out a little bit of the analysis when our registry was first created. And they said that it was that the requirements were really there to contribute to public safety by assisting police investigations and deterring sex offenders from committing new offenses. And unfortunately, we know that this has not actually been the case and the impact of the registry. Some quick statistics on Michigan's registry. We have the fourth largest registry in the country. We have approximately 4,300 registrants as of 2017, and about 2,000 registrants are added every single year, which equates to about 5 registrants a day. And it costs our state $1.2 to $1.5 million each year to fund, which is significantly less than what we receive from the federal grants for actually continuing with SORNA compliance, which I'll kind of get into a little bit later. I'm not going to go through this whole timeline, but the reason I put this up here is to really show how much the registry has changed over the years. And just a few things I wanted to highlight were in 1999, that's when the registry was made publicly available online, which added a completely another level of stigmatism. In 2004, we added juveniles. In 2005, that's when the student safety zones or the geographic exclusion zones were added. And in 2011, that's when Michigan finally conformed with the Adam Walsh Act, added lifetime registration, and made everything retroactive, added the tiers and all of that. You can see there's a massive progression, especially in the early 2000s, that took our registry to where it is now. So I know that this is day 2, and we've heard a ton of information about all the difficulties and all the problems with having a registry and why it just really doesn't work. So I wanted to cover specifically what's been happening in Michigan and some of the issues we've been having there. So generally, there's a ton of issues. In Michigan, we've seen a lot of abuse of registration requirements. We've seen things like law enforcement requesting registrants to give them all of their passwords for every single social media or internet source. We've had law enforcement tell registrants they have to provide DNA or fingerprinting, and there's absolutely nothing within our registry that requires anything like that, and that is certainly a Fourth Amendment violation. But the reason that comes forward is because our registry is so overly inclusive and there's so many onerous requirements and very, very complicated that both registrants and law enforcement alike often don't know quite what they're supposed to be doing, what they're not supposed to be doing, which is a testament to why we need a complete overhaul of the system. Another problem, of course, is the fact that we have lifetime registration, which does not comport with any of the research we've seen about recidivism rates, risk, and ability to reintegrate into society. We know that a lifetime registration is really just a massive punishment. And of course, the registry is over-inclusive. There's these requirements, it's counterproductive, and I'm going to kind of dig into some of these shortly. So the fact that our registry is over-inclusive is probably not something that's new information for anybody that's familiar with registries across the country. Like many other states, our registry requires people to, has individuals placed on it without any type of individualized risk assessment. People are tiered and provided their registration based on their crime of conviction. This means that the registry often includes many individuals, if not most individuals, based on the data, who are not a threat to public safety or to any specific individual safety. For example, in our Doe v. Snyder case, which I will dig into in a little bit, our registry includes a gentleman who had a relationship with a woman that he met at an over 18 nightclub, but she was actually under the age of 16, or she was 16 at the time. And so because they had a sexual relationship, he was then convicted and put on the registry, even though now it's been many, many years. They are married, they have 2 children together, they're still together, and so this individual is required to register for life. And we also have many individuals who've had consensual sex with younger individuals, as well as individuals who have been convicted of quote unquote the more serious crimes, but have received treatment or have gone to therapy, or had really worked through that process and no longer pose any risk to anybody else. Our registry also includes children as young as 14 years old and individuals who have never actually been convicted of a sex crime. So if you're convicted of kidnapping, that will land you on our registry, which is absolutely ridiculous. And again, people are required to register for life, no matter how old their crime is, what they've been convicted of, or how small of a risk that they may pose. So our registration requirements are pretty onerous. It requires all of these things that you see here: your name, social security number, birthday, license number, your address, any place that you've been living temporarily over more than 7 days. So currently you would have to, if you went to stay at a hotel for a vacation that was longer than 7 days, you are required to report that. And I'll talk about kind of the issues around the immediacy portion of those reporting requirements a little bit too. You of course have to report your employer, any school you're attending, your phone numbers of any device that you are using regularly, your email, your instant message logins, your vehicle registration, passport, immigration documents, occupational licenses. And the one thing I did want to kind of briefly touch on is the fact that your vehicle registration requires you to report information of any vehicle that is regularly operated. So this puts an individual's entire family on the registry. So if you regularly operate your son's vehicle or your wife's vehicle or your husband's vehicle, depending on your situation, all of their information is going to go on the registry as well. So we see that these registration requirements have a massive impact on the entire family, not just the registrant. So as been talked about today and yesterday, registries are extremely counterproductive. We know that multiple studies over the past decade, including by Human Rights Watch and various other in Michigan local respected entities, have shown this fact. They show that it makes it much harder for law enforcement to focus their really scarce resources on individuals who they should be, and it makes it much more difficult for registrants to reintegrate into society. We know that registries are not evidence-based, and that's based on the fact that recidivism rates are extremely low, and they're some of the lowest of all individuals convicted of crimes other than individuals convicted for homicide. In Michigan, the average rate for recidivism was only 3.1%, which is compared to the overall 18% recidivism rate across all crime categories. It's also important to note that there's been several studies over the last years that have shown that registry laws actually have little to no impact on reducing arrest rates for sex crimes or for increasing public safety. And I wanted to note here that this was really interesting conversation we had with law enforcement several years ago, or specifically the Michigan State Police Sex Offender Enforcement Department. We asked them how often had they actually used the registry to find somebody that they believed was currently committing a new sex offense, or find somebody that was guilty of a new sex offense. And they said never. That's never how it's been used. They've never been able to find a new person if there's a child missing, or a rape or a sexual assault reported. They've never linked that to somebody who is currently on the registry. And I think that says volumes for how productive and effective it is. And then, of course, as we all know, the registry really does increase ostracism and stigmatization. The fact that it's publicly available in Michigan, and the fact that the individual is just placed on the registry for certain periods without an actual risk assessment makes everyone think when they open it up that every single person is a serial rapist, which is absolutely not the case. And then this, of course, because of the ostracism and all of the laws that prevent registrants from having employment or housing in certain locations, does increase the likelihood of homelessness and unemployment, which again contributes to the inability to reintegrate into society. So impracticability, which of course was described as why this is so impossible to comply with the registry. And there's a ton of reasons, and I don't want to go too deeply into them because I want to get to some of the portions around the challenges we've been setting forth here in Michigan. But there's this vagueness requirement. The definitions in the registry are extremely vague. There are definitions for when a person routinely uses a phone or regularly uses a vehicle, and nobody really knows what that means. It's not been defined. What that means for one individual might be very different than what it means to the other person. And the same is the case with the term loitering. So in Michigan, registrants are prohibited from loitering within geographic exclusion zones, which I'll get to shortly. And the definition specifically says remaining for a period of time and under circumstance that a reasonable person would determine is for the primary purpose of observing or contacting minors. That is so vague. What does that mean? If I am at a soccer game of my son and I'm on the registry, technically I'm not allowed to be at that soccer game because my primary purpose is observing a minor. So we've had a ton of disagreements over this definition, and it hasn't gotten any better. And so the big thing that we have been debating on lately has been the geographic exclusion zones. And these are often called student safety zones, and our act calls them the same as well. And this is defined as being 1,000 feet or less from school property. So under our law, a registrant is not allowed to work or reside within 1,000 feet of a school property. This severely restricts registrants' access to employment and housing. And one study actually showed that 50% of the city of Grand Rapids, this is the city of Grand Rapids, was actually off limits. And so you can see here, the blue is areas that are potentially within 1,000 feet of a school zone. This is really complicated too, because the fact that we don't understand where this 1,000 feet is actually measured from. Is it property line to property line? Is it door to door? Is it all school property? Is it just when school is in session? None of that has actually been specified. And a regular person that's walking down the street just isn't going to know when they're actually 1,000 feet within any of those distances. And so I have here, I wanted to show how different that could be depending on what you're talking about measuring. And so you can see the yellow is a random school. This is, again, within the city of Grand Rapids, Michigan. The dark brown is if we're measuring 1,000 feet from the school property, 1,000 feet, or that is the school property. It's all of their property. The light blue is 1,000 feet from the door of that actual building. The medium blue is 1,000 feet from the building itself, the exterior of the building. And the dark blue is 1,000 feet from the actual property line. So I don't know how any registrant would ever know, based on just that definition, where they're actually allowed to live, where they're allowed to work, or even where they're allowed to stand, which is extremely problematic. It should be noted, too, that exclusion zones are actually not recommended by the Department of Justice. So the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, which is the SMART office, actually released a report several years ago and said specifically that exclusion zones do not actually increase public safety, and they restrict and prevent registrants from being able to integrate into society. So this is not something that's even recommended on the federal level, yet the state of Michigan still has this in their laws, as do many, many, many other states. The next thing I wanted to talk about was something that has come up in various conversations with stakeholders and especially individuals who are against reforming our registry. And this is the concept that the state of Michigan needs to be in compliance with SORNA, which is the Federal Sex Offender Registry Act. And the reason this is, prosecutors and law enforcement can consistently bring this up is because the state of Michigan does receive some level of funding for having compliance. That being said, we did quite a bit of research here, and because of our lawsuits and everything, we've realized that in order to comply with the Sixth Circuit's decision, there are several parts of our registry that are going to have to be taken out or taken down or completely changed. And a lot of that includes things that are specifically mandated by the federal law. So complying with the Sixth Circuit's decision means that there's technical noncompliance with SORNA, but the Attorney General released a statement or some guidance, essentially, that said that any jurisdiction that's unable to substantially implement the SORNA provisions because it would require them to be in violation of their Constitution is determined to still be in compliance. So we constantly are reminding individuals of that, but more than that, we've been reminding them that there are dozens of states that actually are not in full compliance with SORNA, and the state of Michigan is one of those states that has gone well beyond what SORNA requires. And many of those states that are not in compliance with SORNA have still continued to receive funding, and not a single state has ever had their funding taken away. And so here I have a chart of a handful of states that are not fully compliant with SORNA, and you can see what categories they have fallen into where they're not compliant. And you can see that many of these states are continuing to see both their JAG and Adam Walsh funding sources both continue, as well as some of them actually increasing over the years despite being in noncompliance. I thought this was a really important point because often, even if you win the constitutional arguments, this conversation about funding continues to come up. So I've been referring to this all day, but I wanted to talk very briefly about the legal challenges that the state of Michigan and ACLU and various other partners have put forth over the last few years. And I'm not going to go through all of the chronology, but I wanted to just essentially show you that we've been litigating on the registry since 2012. That's when our initial Doe v. Snyder lawsuit was filed, and it was well over 4 years before the court actually ruled on that. And so that was both a district court decision, and then it was appealed to the Sixth Circuit Court on certain elements. And then cert was denied in Supreme Court, which just essentially means that they decided not to take it up. So the Sixth Circuit Court's ruling stands. The Sixth Circuit did not address all of the issues that the district court did. So various parts of SORA come from the Sixth Circuit, or reforms have to come from the Sixth Circuit opinion, and some are going to come from our federal district court opinion. And then we filed a second class action lawsuit, which is Doe 2, just a few years ago in 2018, and that is actually ongoing pending some legislation that I'll be discussing shortly. So I just wanted to give everyone an idea of just how long changing these laws takes, especially from the litigation side. So our case, Doe v. Snyder, the first Doe v. Snyder, was a challenge to the 2000 and 2006 SORA amendments, which covers the tiering system, the reporting requirements, the increase of penalties, and the fact that so much of this was handled retroactively. Our major legal claims were that this was a violation of the ex post facto clause because all these requirements we were arguing are punishment, and that they were applied to individuals after the fact, after their conviction. We also had multiple due process clause violation claims, including the fact that it restricted the registrant's ability to work and travel. There was a due process clause violation about the retroactivity, and of course the vagueness, impossibility, and strict liability standards that I talked a little bit about earlier. And then finally, we brought forward a First Amendment claim regarding the reporting requirements, specifically around how quickly a person needs to report, the information that needs to be reported regarding their emails, phone numbers, all of that information as well. So on our, lost my page. Sorry, on our ex post facto clause claim, the district court ruled against it. We were arguing that it was more of a burdensome punishment imposed for offenses that were committed prior to the enactment of the 2011, but that 2011 amendment still applied retroactively. And the court said that no, that SORA was civil and that it doesn't impose more than a minor and indirect disability on registrants. So they said that registrants still remain free to change their employment, move their residence, travel, and all of those things. Luckily, that was appealed, and the Sixth Circuit said, yes, absolutely, this is a punishment, and it cannot be applied retroactively. Our due process violation regarding the fundamental right to travel, we were arguing that the reporting requirements make it impossible to travel out of state, that the loitering provisions in the school safety zones also make it really extremely difficult to travel. And the reason for that is because if you're traveling, again, for only a few days, or you're traveling someplace where you're staying for longer than 7 days, you have to report immediately, which is impossible. You have to report immediately in person, mind you, which is impossible when you are out of state. So it's technically not feasible to comply with that. And again, the district court here said, no, this is only a minor incidental burden on registrants. And that was extremely problematic, but luckily the Sixth Circuit said that, yes, this is an imposition on registrants' rights to travel, to maintain general necessities in their lives, and especially they ruled on the violation of the 1,000-foot loitering rule. Here. And then again, the district court ruled that, yes, there was a due process violation in the right to educate and upbring your children. This was specifically because of the restrictions that this put on registrants' ability to attend their children's school events, where they're allowed to live, where they're allowed to work, all of those things. The Sixth Circuit did not need to address this, mainly because a lot of the incidents were covered under the ex post facto clause. And so they essentially ruled, and you'll see this for the next few, they essentially ruled that they didn't need to address many of these other pieces because SORA was retroactive and it was punishment and people couldn't be subjected to it. Again, the district court found there was a First Amendment violation. They said that there was not a due process violation because of the registry being retroactive, but they did find that there was a due process violation in the vagueness of certain provisions, such as phones that are routinely used, vehicles that are regularly used, and the loitering provision. So I specifically just wanted to pull out the Sixth Circuit's opinion because it was pretty massive again. So the Sixth Circuit essentially said that our 2006 and our 2000 amendments violated the ex post facto clause and could not be applied retroactively to 2006 or to any individuals who were sentenced or convicted prior to that. And that included the exclusion zones that limited where registrants live, where they work, the lengthening of registration periods, and thousands of people went from 25 years to lifetime registration. So that was massive. And then as well as the imposition of many new in-person reporting requirements. And so again, the Michigan Supreme Court preserved the Sixth Circuit's holding, and so that ruling still stands. So recently, in 2018, again, we filed a class action lawsuit, which essentially asked the courts to apply the ruling in Doe's 1 to all individuals who are on Michigan's sex offender registry. And I should note that's because the first ruling only applied to the actual plaintiffs in that case. So we filed this second one to apply to all registrants. And I have in here, it's Doe v. Snyder, kind of Whitmer, because Snyder was our governor at the time. Whitmer is our current governor, and this is ongoing. This was also a particularly important case because we were arguing the issue of severability. And severability is essentially just arguing that SORA is so integrated and all of the amendments have been so integrated that we can't just take out the amendments and have a statute that's still enforceable, that there's actually no existing pre-2006 or pre-2011 statute in place. It's been so intertwined that if we take those pieces out, we actually have to rewrite the entire statute. And this is something that we are still waiting for the court to rule on. There's been a couple of other cases that have been pending and argued as well that we've submitted amicus briefs on. So the People v. Betts case is currently pending before the Michigan Supreme Court, and it is a very similar case. Essentially, our case was designed to decide if SORA was unconstitutional under the federal constitution, and this case is to decide whether or not SORA is unconstitutional under Michigan law. And if you ever get a chance to read some of the briefs that have been submitted there, they're fantastic. And then there is a People v. Temelkowski case, which was filed in 2000 and decided in 2018. And this case was one essentially that held that an individual who had pled guilty of a registrable offense under a deferred action provision. So that's essentially a provision in Michigan law that allows an individual to plead guilty, complete some level of community service or probationary period, and then that incident, that quote unquote conviction, would not be a conviction on their record. It would not stay on their record. And the court held that any incident like this was not technically a conviction, and that the state of Michigan could not require a person to register who had been sentenced under these types of deferred actions because they made a promise to that person to no longer continue to persecute them when they pled guilty. And it's important to note that that specific provision, which is called the Holmes Youthful Training Act in Michigan, or HIDA, applies only to individuals who are, I think, under the age of 23. We keep increasing what that age is. So it's between like 17 and 23. And Tim will correct me if I'm wrong. So where are we now? We are in the legislation period. have been trying to work on translating all of this litigation into actual legislative reform. So we've been doing stakeholder meetings for 5-6 years now, which essentially includes many individuals like the Attorney General, the Governor's team, Michigan State Police, prosecutors, all of those individuals. And we've come to some very broad agreements. We've agreed that we need to shorten time frames, that there needs to be a path off the registry, juvenile shouldn't be on there, and we need to lessen the number of registrable offenses. Although what that specifically looks like is still kind of up in the air. So in September of 2019, we were having a lot of these meetings, and that was because the court essentially said, look, we will hold off on entering a judgment here. We'll hold off on continuing forward with the Doe 2 lawsuit so that you all can figure this out. And we were unable to figure it out in the fall, so we continued with the lawsuit. In February, the court gave the legislature 90 days to take action, and the legislature didn't. But unfortunately, COVID-19 happened, and the court ordered that we needed more time. So here I've got a handful of legal requirements that we need for legislation based on what all the courts have said. I won't go through these super in depth, but there's around 15 or less requirements that the legislation has to cover, including removing strict liability provisions, including removing a public registry that is tier-based on convictions, simplifying requirements, removing loitering provisions, clarifying lots of vague reporting requirements, removing HIDA recipients, and removing individuals who have been convicted of non-sex offenses, etc. And we believe that the Sixth Circuit also cast doubt on several other areas of SORA, although it didn't specifically say they're unconstitutional. So moving forward with reform, we need to make sure that we are still trying to cover these things as well. So we believe that a sex offender registry that is actually going to be effective, one, focuses on public safety. It redirects resources from ineffective SORA to proven methods of actually preventing sexual violence. It's evidence-based. It's simple for both registrants and police to understand and follow. It's driven by actual public safety principles, not on fear. And it doesn't include children, people with non-sex offenses, or individuals without convictions. And it's designed to actually foster compliance rather than set individuals up for failure. So very quickly, and I'm almost done here, so we can get to questions. There are a couple bills or legislation that are out there. The recent bill in Michigan's legislature is House Bill 5679. I should say 2020, excuse me, and we're opposing it. It actually only has technical fixes, but they're very insufficient, and it remains unconstitutional. It creates a trifurcated registry, making it extremely overly complicated. So there are certain registration requirements for pre-2006 convictions, certain registration requirements for anybody convicted after 2006 but before 2011, and then certain registration requirements for individuals that are post-2011 and moving forward, which is going to make it so much more difficult for anybody to understand what they're supposed to be doing, not to mention law enforcement actually enacting it. And there's a multitude of things that it still doesn't reflect, including many of the principles and policy recommendations that stakeholders have agreed on. But what we do support is the American Law Institute model legislation. And I won't go too in depth there, but it is very well thought through. It's a law enforcement only database. It has very much more simple reporting requirements. It allows for mail and online reporting as well. So some of the key reforms that we have been pushing that are still very, very, very debated are creating, again, a single registry that's focusing only on individuals with high needs. making sure that the registry is risk-based instead of being conviction-based, decreasing registration periods with a path off. So that could look like a automatic review for removal at a certain period of time, plus a petition process for any individual that seeks to get off the registry before their time period is up. Having a non-public sex offender registry, so law enforcement only, and we've had discussions about having a risk onto a private registry or onto a public registry, and there's been pushback there. Eliminating all exclusion zones, which is a non-negotiable for us, and of course simplifying and streamlining reporting requirements. So finally, what's next for the ACLU of Michigan? Well, we want to stop the terrible House Bill 5679. We would like the legislature to continue stakeholder conversations in a way that creates urgency and have a complete overhaul of the registry. And then generally, we just want individuals to take a really hard look at the registry and figure out, is it actually worth the money? And is it effective use of law enforcement's time? And we think that if they look at the data and they look at the facts, the answer will be no. And then finally, we, of course, need to resist adding any new registries, which we've seen happen but we've seen proposed over the last couple of years, including domestic violence registries, child abuse and neglect registries that are completely based on SORA. And we'll just continue to keep working on changing the narrative and fighting fear-mongering with facts. That's it from me.
Tim is here from Michigan, and I've got some questions up, and we'll get the cameras sorted out. You don't need to see all the right faces just yet. Let me see if I can get you some good questions here. So, of course, the big one that lots of people want to know is how can we get the ACLU to do this kind of thing in other states? And and how do we get them involved? And is there any way to get national reform, ACLU involved in that?
Yeah, so the great thing is that having litigated this issue so much, we've got a lot of great briefs and filings that can be replicated in other states. Of course, every court is different. Everybody's federal court is going to be different. So having a good understanding of what your federal court is like and what jurisdictions you are more likely to be successful in is really important. And there are some ACLUs across other states that are looking at tackling these issues, but it always comes down to a capacity. But please absolutely reach out to us if you're interested in filing a lawsuit. We are more than happy to try to work with you and give you the resources that are necessary.
Great. We've lost Tim. I'll hold on a second until we're sure he's back. Can we still hear you, Tim, or did we?
I'm here. Can you hear me?
Yeah, okay. So just in case I ask a question you want to answer, I wanted to make sure that you could jump in. How did Michigan get the information on the costs and that sort of thing and sources?
I can go ahead.
Yeah, please go for it. Go for it, Tim.
Well, it was informally asked of the Michigan State Police how much it was costing them, and they kind of gave us some estimates, but they don't really keep track of it, and they have no idea what it's costing the locals, i.e. sheriffs or local police. So that's where the answer that came from, the numbers. And so it's probably low. It would cost them a lot more than we're showing.
So it's just
Definitely.
what they're willing to admit to, right? What do you think in terms of cases that could reach the Supreme Court? What would it take to do that? A lot of people, and this is a common question we get, is frequently talk about going state by state, such as in Michigan. But a lot of people are saying, why are we doing that? Why don't we go straight to the Supreme Court? So could one of you address that a little bit?
Go ahead,
Yeah,
Kim.
that's the $1 million question. And of course, our current Supreme Court is not likely to be great on this issue right now. I think my answer is probably very similar to my previous answer of it requires, so essentially there would have to be a class action lawsuit nationally, which I think is really difficult because SORA and or whatever any state is calling their particular registry is unique to each state. So you'd have to find where the commonalities lie, and a lot of that would probably be the federal law, which could be challenged. Again, I think it depends on what court you're looking at here, right? And then the other parts of it is finding the right individuals to be plaintiffs in those situations. It's so fact intensive, and it's just one of those issues that the courts in Michigan have been great on, but I don't know that the courts across the country have been as progressive on this issue. So I think some of it needs to be, there has to be some change in what we're seeing in the courts. But certainly the best way to go about doing that is raising the constitutionality claims. And I think what we're seeing is the fact that there are more and more states that are addressing this issue does create some level of precedent. And there is a possibility that there is something that's going to happen on the national level. But having this litigated state by state as a federal issue and as a state issue lays that foundation.
Okay. The MSP, I believe that would be the
Michigan State Police.
Okay. That the division is saying that they never use the registry to find someone. Is that in writing somewhere? And has that been used in the Doe's v. Snyder?
I can answer that.
Not in writing.
Right. It is not in writing, and yes, it was used in the Doe v. Snyder case, but not their statement. Just the fact that
they do use
the outcome. Yeah.
Yeah.
How would you respond to someone who says that recidivism is low because the registry is working?
Well, I can answer that. Kim probably might have an answer also, but the bottom line is there's the data before there was a registry and the data while there's a registry, there has not been much change whatsoever. The recidivism rate has always been low before a registry, and the recidivism rate is low with the registry. As a matter of fact, in some places, there's a little bit of an uptick because people can't find housing or can't find jobs. So there's a little bit of an uptick because of the registry.
Yep. 100%.
Kim, did you want to add to that?
No, that's exactly what I would have said. That's exactly accurate.
Toward the beginning, someone was noticing that progression of the timeline that was showing the laws in your state, and they were asking if there's a similar progression that somebody can find it about their states. I assume you put that together, specifically for Michigan.
Yeah, we put it together specifically for Michigan. Most states, depending on the extensiveness of a state's legislative website, you can find that information. But yeah, ours was specifically compiled. We used our state's legislative website. You can use various other legal research websites, LexisNexis, Westlaw, to find the history of certain laws. And it requires a lot of extensive research into figuring out what was added when. But it doesn't just exist, unfortunately. But luckily, there are quite a few organizations that work on these issues state by state, and they may be better equipped locally to kind of come up with that information.
We've got some people wanting to get in touch with you. Is there what would be the best way to do that?
I can answer that. The easiest way is to, and I'm going to say this, I don't see it on any of the slides, is to contact us by email, and the address is intern, INTERN, at aclumich.org. And
Repeat
then
that if you
we'll,
like, in case somebody was still
yeah,
grabbing their pencil.
yeah, I will repeat it. Intern, INTERN at ACLUMICH.org. And we try to respond. Sometimes it takes us a little time, but we try to respond to most emails within just a few days.
Um, so one person was asking, this is kind of a theoretical question. Courts in some other countries have applied right to be forgotten. What's going on in Europe? Is that something that can or could be introduced here in the United States, okay, for these kind of lawsuits?
Yeah, that's not something we've talked a ton about. It is something that's been brought up before. But to give a quick answer, I don't know. It's possible. We tend to think that taking the constitutionality argument is the best route, but certainly adding in any other arguments that may be feasible, the worst the court can say is throw them out. But yeah, it's not a conversation we've had at the ACLU of Michigan, but I have heard it come up in other contexts. Tim, do you have any thoughts on that?
I just don't think the legislatures at this point has the stomach to address that with this particular class of people.
Yeah, it's a great point.
Right. This is a kind of a comment as well as a question from an attorney who's listening in. She has seen bad law that ends up getting made because of pro se litigants. They haven't had the money to go out and get an attorney, so they try to challenge the law on their own. Could you address that? Her concern obviously was that when you're making constitutional claims, you can end up with a mess trying to do it that way. Can you explain that maybe a little bit?
Sure.
Or disagree if you want to.
Yeah, no, that's definitely a problem. We haven't had quite that issue here in Michigan. There's actually been quite a few attorneys that have been willing to take on these individual cases. But of course, there's a lot of individuals who just can't afford an attorney. I say if you can, absolutely go for it. But if you're an individual who is unable to afford an attorney, do your research on your jurisdiction and on your court. Get a better understanding of the judges and where they may fall on some of these issues, or where they've fallen on other issues in the past. Because, yeah, creating bad precedent is super problematic. I will say that Michigan's situation is probably a little bit differently because we have had this class action lawsuit. So we're less concerned about that. Though we have had many individuals call Tim or email Tim who are looking at doing something like this, and so I think we try to do our best to keep up with what's going on and who's looking to file what and who's looking to go about doing certain things, so that it doesn't conflict with the work that we're doing. Tim, do you have any extra comments on that, maybe based on some of the phone calls or contacts you've been getting?
Yeah, we did get a lot of people asking that, especially at the beginning, and we're starting to getting it again because things are moving so slowly. And we have really been trying to dissuade them from doing any individual lawsuits because, as was said, this could cause problems for ours or make bad legislation that would not help anybody.
Okay. We might start, unless I got distracted while you all were talking. I'm not sure if you really described HB 5679, except to say you hope it doesn't pass as is.
Yeah.
But if you want to describe it a teensy bit more, we've still got just a few minutes.
Sure.
And then the question that came from that is what happens if it is passed? Would the governor sign it, and could it be challenged?
Sure. So yes, I had a kind of breeze through that part, so happy to explain it a little bit more. So the bill essentially, as I mentioned, separates the registry into these three different areas. It does address some things like some definitional changes for routinely and regularly. It tries to change the definition for loitering to make it more specific. Unfortunately, I still think it's unconstitutional. It does change that retroactivity of certain provisions, so that's why there's this trifurcated registry piece, because certain provisions like the tiering and the registration lengths can't be applied to certain individuals. So it addresses that, but specifically only to pre-2006 or pre-2011 registrants, but not moving forward. So there would still be lifetime registration for some individuals. And then the same with their tiering classification. It gets rid of the identification requirement for homeless individuals, changes the immediacy reporting requirements. So right now, individuals are required to report immediately for certain changes. It changes it somewhere between like 7 and 10 days, depending on the type of change, as well as it does remove the strict liability provisions. And so what that is currently, if a registrant violates any provision of the Registry Act, they are automatically liable for that. So they can be rearrested, jailed, all of that stuff. We challenged that, and the courts held that they could not do that. And so this bill will require that there be a willful noncompliance, that a person actually intends to not comply, not simply that they just didn't. There's still some problems with that. And unfortunately, the bill still keeps those geographic exclusion zones, although it did add in some exceptions. Many things are still not addressed. There's still tiers. Again, there's still lifetime registration. Juveniles are still required to register. Deferred action like HIDA, et cetera, still on the registry. There's still in-person reporting requirements. And there's no exception for any individual with developmental disabilities, or as well as they didn't remove email notifications, which were found unconstitutional for certain registrants. So a lot's still going on there. And if the bill passes, which we don't think it will, but if the bill were to pass, I don't know that the governor would sign it, but it's possible. And so if everything passes, it gets signed into law, we're going to have to litigate again. It's just inevitable.
Okay. So kind of related to that, a piece of that bill is involving eliminating that people who move to Michigan from benefiting from any new legislation and holding them to their state's laws.
Yes.
Anything you can comment on that?
Yeah, so this particular bill does do specifically that. It would require that anybody that moves to the state of Michigan has to register under the same registration requirements from the state that they came from. Again, that makes it extremely complicated for law enforcement to keep up with, or for a registrant to continue with. So yeah, that's extremely problematic, which is more of a reason why more and more states, we hope, will follow suit in doing these reforms, and that we can find something that is much more uniform across the board. One of the reasons why the American Law Institute put forward its model legislation, which I think looks really good.
And if I can add to that, Kim, it's my understanding that the Michigan State Police wanted that particular provision in the new bill because they're worried about a lot of people moving to Michigan if our registry changes so drastically from the other 49 states.
Yes, which is pretty ridiculous. I mean, most people don't have the means to just pack up and
Right.
move because they don't like a law.
Right.
Yeah. Most states do try to watch that,
Yeah.
as we are fond of saying, to see all the U-Hauls getting packed up. We had a question come in about what role, if any, the victim advocacy advocates have had in these Michigan efforts, the legislation,
Tim,
and yeah.
you want to answer that
Yes,
one?
they have. Sure. They have had a role. It has not been a major role. They have been on some of the stakeholder meetings. Um, one of the issues is that they changed people a couple times there, and so you have to educate them as to where we're at in those stakeholder meetings. But yeah, there's been some involvement on their part. I wouldn't say they're all for all the changes, but they're not against all the changes either.
Yep.
Let's see here. Got just a couple more minutes. So the ACLU doesn't have any shortage of issues to work on. So who in Michigan ACLU made the decision to focus on this issue?
That is a good question because
I'm not asking for a
it,
name, obviously, but like, how was the
yeah,
decision made?
We're like
the decision
Miriam. No.
actually we started working on it a number of years ago. I've been a volunteer with the ACLU now for over 10 years, and the person that I believe was more responsible for it was the political uh, director now, who received a lot of input about all the unfairness of the registry starting in 1994. And then at the time I came on board in the Lansing office as a volunteer, there was only 3 of us in the office, and the office has expanded a lot now because partly because of this issue and other issues that have come up in the last few years. But we were able to take it on, and as was said earlier, the lawsuit started a number of years ago, and that's where we're at today. Slow process.
Slow process indeed. We are at the end. Do either of you have any final comments, things you wish somebody had asked? Just got maybe 60 seconds or so until we go to the break and hopefully get Dawn up instead of who knows who, and we'll wrap things up.
The only thing I'd like to add is that this is a slow process. There's not going to be an outcome as quickly as people think, even when the COVID-19 emergency is lifted, and people have to be patient. And please don't get mad at us. We're not the ones that are making the decision to move forward. I mean, we get a lot of hate emails sometimes that are blaming us because this thing has not come to a conclusion. We don't want a hasty law written. We want one that's meaningful and will help as many people as we can that are on today's Michigan sex offender registry. Kim?
Yeah, no, just ditto to
Go ahead.
that. Please don't get mad at us. we're
The
doing
wheels
our
of
best.
this kind of thing, yeah, the wheels of this kind of thing just turn very slowly, and it is very frustrating how long it can take sometimes. Okay, well,
Thank you so much to everybody.
Thank you.
We'll move on into the break. Thank you very much, and hope you can all stick around for